Something you want to, if you're just going to read me a giant sovereign citizen objection to my jurisdiction, I'll give you 2 minutes. The right to travel is.
Yeah, and I made that clear to the officer that I was traveling. I wasn't driving. I had that.
Were you in a car?
Film too.
So were you in a car?
Yes, I was.
All right, you were operating a motor vehicle. And were you in the city of Taylor?
Yes.
Okay. I'm not participating in this, sir.
Well,
you know, this is a court of law.
I would have to know because there's no injured party in this case. So
there doesn't have to be.
There does. In order to set a bond against me, there has to be an injured party.
We have a charge of speeding of 11 to 15 over. Do you understand that?
Yes.
All right. Has an offer been made on that, Mr. Zick? No discussions?
No discussions.
Would you like to have discussions with him regarding that civil infraction?
Yeah, I would like it dropped.
Okay. Well, I don't know that he's doing that, but he might offer you a reduced ticket with no points. I mean, I don't know that he will. I don't know what he'll offer you, but there could be a reduction. Do you want to discuss that possibility with Mr. Zick?
Yes, I'd like to.
Okay, I'll let the two of you discuss that. And I did receive your filing. I'm reviewing it now.
Okay.
So if that's what you're intending to put on record, it is officially part of the court file.
Okay.
So we don't need to do it orally because it's part of the file.
All right.
Okay. All right. I'll let you two talk and I'll see you back in just a few minutes.
Thank you.
All right. We're back on record. Were you two able to have discussions?
We had the discussion, Your Honor, but we're unable to reach resolution.
Okay. So was an offer made?
Yes.
Okay. Can you just tell me what?
Can you explain the offer that was made? Yes, Your Honor. The prosecution is willing to lower the speeding violation to a non-point traffic infraction. All right. Mr. Page, do you understand that this would be treated as a civil matter? The fine would be $165, and no points would be added to your driving record. Yes, I understand. And you've decided not to accept that offer? That's correct. Very well. We'll move forward with the hearing. Mr. Page, before we continue, is there anything you'd like to present to the court? If you're planning to read a lengthy statement challenging the court's authority, please let me know so we can address that appropriately.
I'll give you 2 minutes to put whatever you want to put on record, and then we're proceeding with the hearing. Fair?
Don't I have the right to be heard lawfully?
We have the right to ask questions to the witness.
Okay.
And to, make any arguments you want to the court.
Right.
But as far as jurisdictional arguments, the court does have jurisdiction.
Okay. Is this court operating in administrative or judicial law?
I'm not participating in this, sir.
I would.
Well, this is a court of law.
I would have to know because there's no injured party in this case. So
there doesn't have to be.
There does. In order to set a bond against me, there has to be an injured party.
Okay. Anything else? I am operating under the laws of the state of Michigan and the Michigan Constitution. And that's the information that I'm willing to provide. And and I'm certain you're aware of that, sir. You've lived in the United States for your life.
And I'm also aware that I have the right to freely travel at my own vehicle.
Correct.
That I maintain and take care of. There was no injured party. I was not engaged in commerce or commercial activity.
Okay. Well, they can get tickets too for speed.
I'm protected under the Constitution. Speed limit's not law. The Constitution says that.
Actually,
the speed limit is statute, code, and ordinance.
Correct. Statute and ordinance. That's correct.
So how can I be charged if we're operating under this type of law and no injured party?
Well, your federal right to travel under the state or the federal Constitution doesn't mean that you're not subject to regulatory. I mean, do we not have to get driver's licenses? Do we not have to get car insurance? Do we not have to follow basic speed laws? I mean, you can have a constitutional right with limits and or regulatory provisions or statutory provisions. The right to drive is not written in the Constitution. the right to travel is.
Yeah, and I made that clear to the officer that I was traveling. I wasn't driving. I had that.
Were you in a
I had
car?
that film too.
So were you in a car?
Yes, I was.
All right, you were operating a motor vehicle. And were you in the city of Taylor?
Yes.
Okay. All right.
I wasn't operating a motor vehicle though. I was traveling freely down the road.
In a motor vehicle.
That I maintain and take care of myself. That's my property.
Okay. I understand that. That doesn't affect this. I mean, you were driving a car in the city of Taylor. Yes. Okay. And that's why we're here.
Okay.
Okay.
Your Honor, people who waive opening at this time would be prepared to call their first witness when you're ready.
Okay. Call your first witness.
Thank you, Your Honor. At this time, we call Corporal Billy Schillenberg to the stand.
Corporal Billy Schillenberg, badge number 260.
And you're employed with the Taylor Police Department?
I am.
And what's your position with the police department?
My rank is a corporal and in the traffic bureau.
And Mr. Schillenberg, were you working back on November 4th of 2024 in the afternoon hours?
I was monitoring traffic on southbound Telegraph, south of Brush Road, when I observed a silver Ford Fusion traveling faster than the vehicle around it. Which time I activated my LiDAR device, which I am trained and certified to use in the state of Michigan. Pointed the LiDAR directly at the hood of Mr. Page's vehicle and received a reading of 58 miles per hour and 45 mile per hour zone. The way the LiDAR works is when you point the LiDAR at the hood of the vehicle, it'll give you a speed reading and a feet reading. So the feet is the distance away from where the LiDAR is to the vehicle approaching that position.
And based on the reading that you received of 58 and you were monitoring a 45 mile an hour zone, what did you do?
All right, let's clear that up. I may have understood the answer differently. You certainly have the right to raise an objection. Let's have the witness explain further. Officer Schillenberg, could you please clarify your previous statement? Yes, I was positioned on the west side of Telegraph Road, observing traffic from a parking lot. Was that the parking lot of Turbo Motors at 12200 Telegraph Road? Yes, that's correct. Okay, then what happened next? As the vehicle passed my location, I pulled out from the parking lot, followed behind it, activated my emergency lights, and conducted a traffic stop. All right, and the stop took place farther down the road at 12510 South Telegraph? Yes, near the Enterprise location. Enterprise? That's correct. Understood. During that time, did you keep the vehicle in sight continuously? Yes, I maintained visual contact the entire time.
Okay, do you have some questions for the witness? You're free to step to the podium just so the court reporter can take everything down.
No questions to the witness.
Okay. All right. Your excuse, Corporal Kish. Thank you.
People rested this time, Your Honor.
All right. Do you have anything you want to enter into the record?
I want to enter into the record that I'm here today making special appearance under sue juris as one of the people of Michigan, not as a defendant under the jurisdiction of this court. I'm asserting my unalienable rights as secured by the Michigan Declaration of Rights under the United States Constitution, particularly under Article 1, Section 1 of the Michigan Constitution, which establishes all political power is inherent in the people. At that outset, I raise jurisdictional challenge to this court.
Your Honor, may I interrupt? And I apologize for interrupting, but Corporal Schillenberg is our traffic supervisor, and there's been an issue over the Taylor Police Department this morning.
He's free to go. Do you have any other questions for Corporal Schillenberg?
No.
All right, Corporal Schillenberg, you're excused.
Thank you.
All right, go ahead, sir.
This outset, I raise jurisdictional challenge to the court, as jurisdiction must be proven on the record before any further proceedings can lawfully continue. The separation of powers doctrine, as outlined in Article 3, Section 2 of the U.S. Constitution and the Michigan Constitution, makes it clear that no branch of government may exercise the powers of another. Before proceeding, I require clarification on whether this court is operating in a judicial capacity or administrative. If this court is acting under administrative directives or executive branch policies, rather than operating as a constitutionally recognized judicial body, then it is exceeding its lawful authority. No administrative agency, including the SOS, possesses lawful authority to direct judicial rulings or override the people's due process rights. Any attempt to enforce such directives constitutes an unconstitutional exercise of power, rendering these proceedings null and void ab initio. Furthermore, jurisdiction cannot be established by assumption, presumption, or coercion. Due process demands that I am provided with clear, lawful authority establishing the legitimacy of this court's jurisdiction over me, an individual exercising my constitutionally protected right to travel. Without such proof, this court is proceeding without lawful authority, and any ruling is issued a legal nullity. I now formally demand that this court place on the record the specific constitutional authority establishing jurisdiction over me as one of the people of Michigan, the legal basis that allows this court to act under administrative directives or executive policies without violating the separation of powers doctrine, proof that I was engaged in regulated commercial activity as no jurisdiction exists, absent clear evidence that I was operating as a licensee in commerce at the time of the alleged incident. Until these fundamental issues are resolved, I will not proceed under any assumption that this court has lawful jurisdiction over me. To do otherwise would be to waive my inherent rights, which I do not consent to. I stand firmly on my right to due process, equal protection, and the supremacy of constitutional law. The burden is on the prosecution and the court to establish jurisdiction before any further action can lawfully take place.
All right, thank you, sir.
You're welcome.
All right, I heard testimony today from Corporal Billy Schillingberg. The standard for these hearings is not beyond a reasonable doubt. And there was no questions to Officer Schillingberg that offered any contradictory testimony to the testimony that was issued in this case. Therefore, Mr. Page, I find you responsible of the civil infraction of speeding 11 to 15 over, and that has a fine of $130. Mr. Page, do you need time to pay?
I do.
Okay. How much? Can you pay in 30 days?
I mean, yeah, if I got on a payment plan.
All right. Well, would you rather pay something on a monthly basis?
Sure.
Can you pay $70 a month, $50 a month? Tell me what you
50's good.
50 a month.
Yeah.
All right, they'll send you notice of the payment plan. Are you in Hidden Lane still?
Yes.
All right, Mr. Page, you'll receive notice of that in the mail.
At its core, this case came down to one straightforward question. Was the driver traveling above the posted speed limit in that area? The defense tried to focus on broader legal theories and questions about authority, but those arguments did not directly address the key issue before the court. In a civil traffic hearing, the primary focus is the evidence related to the alleged violation. The officer provided testimony regarding the vehicle's speed, the location of the incident, and the identification of the driver. Once that evidence was entered into the record, the most effective way to challenge the case would have been to dispute the facts, question the accuracy of the speed measurement, examine the officer's observations, or challenge aspects of the traffic stop itself. Instead, the defense concentrated on arguments that did not directly challenge the evidence presented. As a result, the court was left with only one detailed account of what occurred. Several decisions had a significant impact on the outcome. A reduced charge was declined, no questions were asked of the officer, and no alternative explanation of the events was presented. Without competing evidence or testimony, the judge had limited information to consider beyond the officer's version of events. Courts base their rulings on the evidence and testimony entered into the record. In the end, the court imposed a fine, provided time for payment, and offered a payment arrangement. The process moved forward through established legal procedures. This case highlights an important lesson. Success in court often depends less on making broad legal arguments and more on directly addressing the evidence. Small strategic decisions can greatly influence the final result, and the difference between appearing confident and presenting an effective legal defense can be decisive.